only person found dead was the driver, who police say shot himself inside the truck before it blew up, injuring 7 people. He's been identified as an active-duty U.S. Army soldier, Matthew Livelsberger, who was home on leave.
2 sources familiar with the investigation told the New York Post Livelsberger left his Colorado Springs home following an argument with his wife over infidelity. His wife, who had a baby daughter with Livelsberger, reportedly told him she knew he'd been cheating, the source told the Post.
That's Fox's Deborah Valentine. Another American soldier is facing criminal charges in Washington state.
A U.S. Army soldier based at Fort Cavazos in Texas has been arrested and charged with selling confidential phone records, including material allegedly stolen from President-elect Trump and Vice President Harris. In December, a grand jury in Seattle indicted 20-year-old Cameron John Wagonius on 2 felony counts of leaking confidential phone records under the online alias Kyber Phantom. Fort Cavazos told Fox News Digital it's aware of the arrest but offered no other comment. Carmen Roberts, Fox News.
2 people are dead in Fullerton, California after a small plane's fiery crash into a building, a facility manufacturing furniture. 19 people inside were injured. The pilot had issued a mayday call.
It's actually a kit airplane that the owner of the airplane can build and maintain themselves.
So Elliot Simpson with the National Transportation Safety Board says they'll be going over those maintenance records. On Wall Street, stocks could rebound. Dow futures up more than 100 points the day after losses to start the new year. In college football, Notre Dame beat Georgia 23-10 in the playoff game delayed a day by that attack in New Orleans. Notre Dame will next face Penn State in the college football playoff semifinals. I'm Dave Anthony.
Lawrence County depends on WDXE News, on the air since 1951. This is The Legend. 105.3, 95.3, WDXE.
It is 8:07 and time for Bulletproof Estate Planning with my good friend Stan Pierchoski. Stan, good to see you again.
Good morning. Good morning. How are you?
I'm doing great. Missed you last week, of course, through the holidays and all that kind of stuff. But
I did miss you. Did you have a good holiday?
We did. Did you?
Yeah, wonderful, wonderful. Had a little stomach flu get in the house, but other than that, it was a good time.
You know, there's been quite a lot of that going around.
Yeah, my wife. I don't do Facebook much, but my wife does, and she said everybody and her brother is saying it. You know, they've got it, they've got this, they got that. So yeah, might as well get it and get it over with, I suppose.
In fact, I heard one report this morning. Yeah, you're up pretty loud, but you may want to start right straight in, and we'll be okay. I got you up pretty high there. So we should be good.
Okay, good.
But yeah, I was listening to a report this morning, as a matter of fact, and they were talking about how that the sickness could probably go on for another week or two. A lot of that going around.
Oh, it'll pass. It is July. I mean January.
It's January.
Freezing cold. Yeah.
Freezing cold in January. Well, did you watch any football over the?
Actually, I did not. Well, you know, my wife. I watched some. College, you know, but other than that, I'm not a big football fan anymore until it comes time for the playoffs. Then I'll watch the Super Bowl.
I'm kind of that way too. As far as pro ball,
I keep up with it a little bit, but not as much as I used to.
Yeah, I keep up with college ball better than pro ball, but it's just exciting, and of course having a grandson that really likes it to watch it with me, that's more fun. So.
There you go. There you go.
Well, what's going on in our world? Of course, you've got a seminar coming up end of the month.
I do, the 25th. So that'd be about 3 weeks from tomorrow, I reckon.
Yes, sir. Yeah.
So, and it's a Saturday, and it's here at the WLX radio station at 10 o'clock in the morning that Saturday. So, called Will's Trust in the Nursing Home, and if you want to come to that, it's not too early to RSVP for that. We've already got some sign-ups, quite a few if I remember right. The girls are telling me. So, yeah, it's going to be here at the radio station, back of the building.
Very good.
The Country Cafe there. We're got plenty of room to spread out and you know, put out tables and chairs for folks to sit and take notes and pay attention.
Yeah. Well, we've got somebody who wants to chime in already.
All right.
It's our regular caller she's always got something interesting to talk about.
I haven't even started a subject.
Haven't even started yet. That's right. Hey, how are you this morning?
Well, I tried to chime in. Is it better to sign up and not show up, or to show up and not sign up? Exactly, because I have something major going on in my family that I honestly don't know.
Yeah.
But, if he would comment on that, and then I'm going to cover 3 things he may not can cover today, but I think would be really useful to me and possibly other people if he would. With your chit-chats about things, I have heard him say more than once that he can't say he's an expert. And I read that even if you have a Juris Doctorate, you are not supposed to call yourself doctor, and I wondered why. And I also wondered about the difference between an attorney and a lawyer. I kind of know, and is it the same in all states? But I'm just going to throw those out for some of the casual things that I don't. But I want to get to the more serious right now. I also heard and read for the first time that it was safer. Now, this is for the first time for me. I'm sure it's not for y'all or him. That your chance of having identity theft is less if you have a trust than if you just have a will. And I would be interested in knowing, and probably other people would, why would that be if that is true, and is it true?
All right. Well, good questions.
Okay, well, I've got one more, and this is
Okay.
a real serious one, and I'm not trying to hog the time, but I read also that a trust can be dissolved, and the example was, and I've heard him say several times, you can't have anything illegal in there, and it said that if something is decided it's illegal after you've written it, the person who wrote, I guess it's the grantor, he needs to clarify this if he can, the beneficiary has to agree, and if they can't come to terms and agree, it can be dissolved. And I would like to know what kind of example of that could happen. Does he know of one? And he may not be prepared for that today. And that's if you're still alive and you notice it, you could probably easily be resolved. But let's say it's not noticed until you die.
Yeah. Okay.
And then how would that be resolved? And how? But if he could go into that, I just thought that was interesting. I did not know, and I'll hang up.
All right. Thank you. Quite a lot there.
Yeah.
The expert thing.
The expert thing. Well, we have a board professional conduct,
Yes.
ethics, professional ethics, and stuff like that. And unless we're typically not supposed to say you're specialized in something or you're expert in something.
Right.
Because as an attorney, you're supposed to be familiar with the law, and it kind of boils down to one thing we're not allowed to do is guarantee a result.
Yes.
You know what I mean? And so typically, now if some people go through some specialized training, they can say they specialize in a certain field or something like that. And those are really kind of like our rules of advertising more than anything else.
Right.
So, and I don't know if I ever said I didn't say I wasn't an expert. I feel very versed in what I do. You know what I mean? I'm very comfortable and familiar with the area of law that I practice. But when you talk about an expert, that's more of a term that goes towards testimony, like at a trial.
Yeah.
You've got a person that is an expert in a particular field, and I think that's kind of where she might have been going, because we're an expert. When you have a trial, you got two kinds of witnesses: expert or a lay witness.
Yes.
A lay witness can only testify to what they saw, heard, or otherwise perceived with their senses.
Right.
Where an expert can actually give an opinion. When you're a lay witness, you typically cannot give an opinion unless we lay some kind of foundation. But an expert can say, well, based on the length of the skid marks and the all the other things at the crash scene, I can make, in my opinion, the car was traveling at such and such a speed or something like that. But that's based on their experience and knowledge of all that, and they weren't there to actually see anything. But they can give an opinion on what happened. Now, so I don't know if too many attorneys actually claim to be experts in anything.
Well, I wonder, and I have wondered this before myself, that it applies more to attorneys who advertise themselves in one way or another.
It does.
There's some rules regarding how they can do that, I'm sure.
You can say your specialty in something, but you have to have some a certain number of hours of specialty training in that area. So, and most attorneys do more than one specialty. They like estate planning. I couldn't say there is a specialty because there's a lot of topics that fall under estate planning. Some of the stuff we're going to talk about as a result of the call, but there's a lot of things in that area.
Yeah,
so,
yeah.
But what was the next one?
She mentioned
I was trying to keep notes.
something to do with the ID theft. I'm not sure how that applies to this, but
I don't know if I can help much with that. And that is, I don't know what it takes to steal somebody's ID, but she said between a trust and a will.
Yeah, I'm not.
Although I did have this question just the other day about with a trust, and I'll see if I can make some sense out of it. If you have, I don't think a will would have anything to do with it, and I'll tell you why. A will is a document that nobody sees until you actually pass away, right?
Right.
So I mean, if you can glean something from somebody's will and steal their identity, I don't know how they're going to get hold of the will.
Yeah.
And if the only time it's ever published is when you open a probate case and publish the will. And even then, now it's too late to steal somebody's identity because they're gone.
Yeah.
But with a trust, some people have asked me, when not necessarily identity theft, but this title theft.
Okay.
You know, you see the commercials on TV about title theft, and
That's correct.
people steal your home.
Right.
And I don't think it's much of a worry, to be honest with you. I mean, I know they talk about it, but I've read several state attorney general opinions on several states that have opined on those, and they're pretty negative about the services that people offer, because all it does is monitor your title, and it'll let you know if somebody takes it.
Yeah.
I mean, it'd be a whole lot nicer if you paid for service and they let you know before they took it.
Yeah.
But I mean, you know, you can monitor it and figure it out that somebody took it already. But one thing about that, I've never known anybody that had a title theft.
Yeah,
okay?
and I haven't either, and I can't imagine how it would even be done.
But I think if you have a trust, you got an extra layer of protection, and here's why. If you have a trust and you put your house in it, and I'm sure you can relate to this as it being real estate. Whenever you would sell, you know, whenever one of my clients want to sell a house or buy a house or something like that, you know, the people that get involved, the buyer on the buyer side, the seller side, and typically a title insurance company somewhere, they will ask for, because it's a trust, they'll ask for what's called the certificate of trust, which defines who has the authority to actually sell the real estate that's in the trust, right?
Right.
And so we usually always have to produce that document for them whenever the sale is going on. So that's another document that has to, I mean, they'll never let the sale go through until that is produced, because we want to say, okay, we got this trust, who's had the authority to sell this house? You know, we got to make sure the people selling it are the ones that have the authority to sell.
That's right.
And so that's another layer of things that have to be accomplished, which I really don't know how they could hack into something like that, but because you have to produce that at the time. So I think that's an extra layer of protection for that title theft. Now, as far as identity theft, I don't have an answer. I don't know how people steal identities, and I don't know that it's ever happened to me. But I mean, I've had things like credit cards compromised and stuff like that. But
Right.
I don't know. That's definitely not in my lane. But,
Now, I wouldn't think that identity theft itself would affect a will or a trust.
I can't see how right off the top of my head. But anyway.
Yeah.
Both
All right. Well, the other question I thought was somewhat interesting about arguing over, or can a trust be dissolved, and if so, how, and under what circumstances, and if the person that the trust is for is deceased, you know, how did that happen? Anyway, and I'm sure everything can be argued, but whether successfully or not, that's the thing.
Well, you know, you have two main categories of trust. One's called a revocable trust, and one's called an irrevocable trust. Okay.
Yeah.
Now, a revocable trust can be revoked at any time by the party called the grantor. Now, I call him the trustor, but the grantor is the maker of the trust.
The maker.
You have three parties: the trustor, which is the maker of the trust; the trustee, which is the person that controls the property within the trust; and the beneficiary is for whom is this agreement drafted to benefit. And so, if it's a revocable living trust, the grantor can revoke it at any time. Can make as many changes as he wants to make at any time. And so, during life. Now, when you have a revocable trust, at death, or if you're a couple and it's a joint trust, at the second death, that trust becomes irrevocable at that time. You cannot revoke it now. It can't be changed, because it can only be changed by the maker of the trust.
Okay.
And that's the way it should be, because after death, if they want their property to go a certain way, we don't want somebody substituting their judgment for the deceased's and modifying that. Okay. But for the revocable trust, you want to make a change to it during life, it's a stroke of a pen away.
Is there any merit or any reason that someone who's living and creates a trust, that they're the creator of the trust, would make it an irrevocable trust?
Well, the irrevocable trust that we do is that one we talk about, the asset protection trust, where we protect property from long-term care.
Oh, okay.
That is an irrevocable trust. Now, let me just mention something. That you got the term revocable and irrevocable.
Yeah.
They're not very descriptive. They sound like they are, but they're not. And so, what's the difference between a revocable trust and an irrevocable trust? And the answer is not one's revocable and one isn't. You can revoke an irrevocable trust. Now, that sounds like a bunch of lawyer double talk, right?
That's about what I was going to ask.
But our trust, this will dovetail right into the answer to this question, too, because an irrevocable trust can be revoked, and our trust code is very clear on how to do it. Okay, an irrevocable trust, the definition between the two is on an irrevocable trust, the trustor, the maker of the trust, cannot be a beneficiary. which is what gives us the creditor protection we seek.
Okay. Okay.
You can be the trustor or the trustee, but not the beneficiary. Okay. Now, you can revoke an irrevocable trust, and what she was reading sound like it was getting pretty close to the mark, and that is, if you want to revoke an irrevocable trust, the trustor cannot revoke it unilaterally, like he can a revocable trust. Unilaterally meaning just by himself.
Okay.
You have to involve the beneficiaries. So if I have an irrevocable trust and I leave the property in there to my 3 kids, if I want to revoke that trust, I need an agreement between myself and the beneficiaries that they agreed to revoke it.
Oh, okay.
Because they're involved. It's irrevocable, and it's going to them. They have a vested interest in the trust.
Okay.
Now, if it's a revocable living trust, you're a beneficiary at the whim of the trustor. I mean, if you write them in or you can write them out. So you don't involve them. If you want to revoke it, you just revoke it yourself. Now, we revoke trusts from time to time, and there's reasons why you would. There's several reasons. They're usually circumstance-driven. But, I mean, the fact is you can revoke an irrevocable trust. When it's irrevocable, it doesn't mean you can't modify it. There's certain things you can still modify in a trust. Asset protection trust, about the only thing you really can modify or amend is where a property goes after death. And it's a little different process to amend it. It's called exercising a power of appointment rather than just writing an amendment. But nonetheless, you can modify those. So, it's not dissolve a trust; it's revoke a trust. Revoke means to rescind it, take it back, and make it no more.
Sure. And
all trusts revoke after their purpose. So if you have a trust and there's no property in it, like let's say you have a trust and years go by and all the property's been taken out of it and you never put anything into it. You can revoke it under what is called frustration of purpose, and it has no. A trust without property has no purpose, and that's what happens after death when you distribute the property in your trust. Your trustee distributes the property to who the beneficiaries are, and the property's all gone. Then that trust will terminate. It'll go through revocation and terminate. So it's not a big deal to revoke a trust, but dissolve. You get the idea with the word.
Sure.
But,
sure.
So that's what makes them fluid documents. I mean, like the asset protection trust is an irrevocable trust, and it needs to be to get that creditor protection. Because if you can revoke, if you have that kind of access and control of the property, then you don't get the protection that we want.
I see. It makes sense.
Sort of have to give something up. So.
It makes sense. And what's interesting about that, though, you mentioned there that something about you could change. Make some kind of change in that trust or whatever.
Yeah, sure. I mean, if you had, I'm sorry, I didn't mean to interrupt. Go ahead.
That's okay, but that seemed like the same thing that you can do with a will. People say, "Well, I'm going to change my will. I'm going to change my will. I'm going to change this," but a will doesn't have a category of revocable or non-revocable.
No, you can revoke a will.
You can.
I mean, it's a little different. You can get rid of a will.
Yeah.
You can revoke it. There is a revocation of will statute.
Okay.
Typically, I'd say 99% of the time, if you're going to revoke a will, it's because you're writing a new one.
Right.
And then every will says in the very first paragraph that this will supersedes all prior wills or codicils. So the latest one in time is controlling. Okay.
Yeah.
And then we have a statute that says, and then people say, what do I do with the old will? What do I do with it? Well, you can keep it or you can revoke it. And if you go to the statute on revocation of will, what would you guess would be the legislature's first suggestion on how to revoke a will?
What would I guess?
Yeah.
I don't know.
Destruction.
Oh, just tear it
up, burn it, throw it away. Yeah,
tear it up, burn it up.
Destruct it, or have somebody destruct it for you, like an agent or something like that.
Yeah.
So that's how you revoke a will.
You just get rid of it.
But if you get rid of it, then you don't have a will. And so most people, when they get rid of a will, they actually replace it with a subsequent.
Yeah.
A superseding will.
Yeah. And the will with the newest date wins.
The latest in time controls. That's right.
They control.
Now, that brings up a thought. If you have a will and you're leaving it, let's say you got 4 kids and you're leaving it equal shares to 4 kids.
Yeah.
And you decide that you want to change it. Now you want to leave it all to 3 of them and cut one out.
Yeah.
I would recommend destroying the prior will. And here's why. If you can defeat the existing will, then the latest in time controls. And that somebody may take better under a prior will than the current will.
Yeah.
And that's just the thought process.
Now,
if you do the will right, you don't have to worry about it.
Are wills recorded?
No, there's not.
I didn't think so.
They become part of the court record once you open probate and after death.
Yeah.
So they become public upon death.
Interesting.
And there is a statute that says you can take it down to the circuit court clerk's office, and they'll lock it in the safe for you, but they don't record it.
Mm-hmm. Very, very interesting. Very interesting. And, we run into this a lot, and they need to be kept safe somewhere.
Yeah, they do. Because if you don't have a will, you don't have a will.
If you don't have
a
will, you don't have a will.
If you can't find your will, you don't have one. Now, there is a lost will procedure, but you got to jump through all kind of hoops, you know what I mean?
Wow.
But I always tell people when they do a will or a trust, I say, tell your family that you have a will plan or you have a trust plan and where it is.
Yeah.
Hey, I have a will plan or a trust plan. It's under the bed. Okay. When I say a plan, because we usually have things like power of attorneys in there as well.
Right.
And if something happens to you, now their authority to act on your behalf resides in those documents.
Right.
And so they need to know where they are and get to them. So if you put them in your gun safe, make sure they have a way to get into it.
Yeah.
Or bank vault, make sure they can access that if they need to.
Yep. Now, I would assume that if you've had an attorney prepare a will for you, that they'll have a copy of that will.
Not typically. Some do, but I don't.
Really?
I don't keep I don't.
Yeah.
Because, I have a copy, yes, but I thought you meant the original.
No,
the original,
not the original.
No. Yeah.
Not the original. Yeah. Okay. Interesting.
And nowadays you can scan the copies because these scanned documents now are considered originals.
Are they really? Very good.
What else was there?
The difference.
You were taking notes.
I was. The difference between a lawyer and an attorney, if any.
Don't know what to answer that. Actually, those are more modern terms.
They are.
Back during the common law, you were a barrister or a counselor.
Mm-hmm. There's a lot of other names for lawyers.
Yeah, that's right. That's right. So I don't know if there's a difference between the two. I'd never wanted to use the brain cells trying to figure it out. So
interesting. No, I guess they're just interchangeable terms. I haven't actually really even thought about it.
No,
attorney at law. You see that?
Attorney, I think, is the more official word. But
yeah, it probably is more formal.
When you do a power of attorney and you appoint your agent to do something for you, they are often referred to as my attorney in fact, which I think is confusing. But I just use the term agent in my documents. But nonetheless, that's attorney in fact. It doesn't mean you're being somebody's attorney. The attorney, I think the word attorney stems from representing another.
Okay.
Yeah.
Very good. I'll have to give that some thought myself, just because I'm curious about it now.
Maybe we'll look it up and see.
I'm kind of curious about it now.
Right.
Very interesting. Very interesting. Well, in my line of work, I have the privilege of interacting with a few lawyers here and there, and estates. So all this is kind of interesting to me all the time. And we usually run into something unique and different, it seems like almost every time.
Yeah. Was that the last question?
That was the last one, yes.
Okay.
Yes.
It's good questions, I suppose. And
yeah. Got to start it anyway.
It's thought-provoking.
Got to start it. I mean, by the way, it's a whole new year.
It is. It is.
We're a whole new year, and this would be a great time for you out there, folks that are listening, to think about. I mean, really, if you haven't done any planning, estate planning, then why not make that one of the resolutions?
There you go.
To get this ball rolling. Pierchoski Estate Law. I can't think of anybody better to help you with it.
Oh, thank you. People will ask the generic question like, "What is estate planning and why should I do it?"
Yeah.
Estate planning is a pretty big topic. Okay?
Yeah.
I mean, there's a lot involved in that.
Yeah.
And so, if I want to distill that down into its simplest forms, I told you that sometimes we talk about the biblical perspectives of estate planning.
Right.
There's nothing new under the sun when a person wants to, manage his own estate. Okay.
Yes.
So you think of it this way: you're born into this world. You're born into a family, right? I don't know how long you're going to be here, but the only thing I'm sure we can agree on is that it is a finite amount of time.
It's a finite amount of time. Yes.
And while you're here, certain things become very important to you. So when you're born into a family, your family is very important to you. And then if you grow up and start a family of your own, that becomes very important to you. And so one of the most things that get most people thinking about estate planning is when they start thinking about their family. If you have if you're a young person and have a spouse and young children, the thought has to cross your mind, what's going to happen to my family if I'm not here?
Sure.
It's not about money, but you can't take care of a family without wherewithal, right? So you have to be doing something. And if you disappear and there's something happens to you, something needs to take your place, at least financially.
Right.
So people say, well, what I might want to do is, take out some life insurance. So if something happens to me, they'll have enough money to pay the house off and have a place to live. I mean, that's just, that is actual planning. That's
correct.
It's only prudent that you would do that. And then. So you want to take care of children. You want to take care of a spouse. You may have elderly parents that you're taking care of. And then when during your lifetime you accumulate your wealth. When I use the word wealth, that doesn't necessarily mean a lot of stuff. It just means whatever you have, right?
Right.
And everybody's wealth is their wealth, and everybody's wealth is important to them. And if they want their wealth to take care of them and their family, and if anything's left over, they usually like to leave it to the subsequent generation. And so that's those goals that are instinctive in mankind. They've been doing that since the dawn of time.
Yes.
And so there's nothing new under the sun, and it's just basic human nature to want to do that. And that's what planning is. So when you think about it, the planning part is doing something about that. Because if you don't do something about it, then it's not going to get done the way you want it. I saw a commercial over the holidays on the online will writing service, like software or something.
Right.
And there was these two guys standing out looking at a car, working on a car, dad and the son or something. And the dad says, son, when something happens to me, I want you to get everything. And all of a sudden a car creeper comes out from underneath the car and there's a guy on it. And he says, oh, not good enough. And then they go on about this thing saying, write a will, put that thought down in a will. And that's exactly right. Just saying it to somebody is not enough. Now, I get a lot of people that tell me this. I've talked to my kids. They know where everything's supposed to go.
Yes.
And I know people are comfortable with that. And that probably works a lot of the time, or at least the knowledge of where it's supposed to go.
Right.
But it's probably not the best way to do it. If it's important to you that it go a certain way, you need to memorialize it somehow.
Yeah.
And make it into something enforceable. Make sure that happens, because we could write a book on what happens to families when inheritances get involved.
Yeah, and I think people put it off because they feel like it's not an easy conversation.
I think so too. Just mortality in general, right?
Yeah, exactly. But I think once you do that, there's such a good sense of relief and satisfaction, I guess, that the matter is taken care of, and it doesn't have to be that something out there that you're always thinking about you should do, but you haven't done.
A lot of my clients feel like they have a tremendous weight lifted when they get this stuff taken care of.
Yeah.
And it's marked off their list, because it is very procrastinated. But like I think you've heard me say before, I think it gets procrastinated because a lot of people are not sure what they can do.
Yeah.
They're not sure what the options are.
Sure. Well, I certainly didn't know a lot of the options.
Well, there's certain things that you just have been ingrained to think about, because it's always, when you search the topic or Google it or talk to your buddies, it's always the same answer.
Yeah.
A classic example of that is this long-term care concept.
Oh,
I think if you ask anybody, they'll say, oh, there's nothing you can do. They're just going to get it all. You're just SOL. You go to a nursing home, they're just going to take everything you own. Just throw up your hands and say, that's it. You can't do anything about it. And that's really not the case. But if you research it on the internet and talk to people, that's the answer you get. That's the general understanding, and it doesn't have to be that way.
Right.
So knowledge is a power.
I run into a lot of folks doing what I do. I run into a lot of folks who have put themselves in a circumstance where their parents have deeded their property to them in years past, because they have this general knowledge of this 5-year thing.
Right.
And sometimes that blows up.
Yeah.
Because it didn't work like they thought it was going to work, or it had circumstances surrounding it that they didn't see or anticipate. And I had that happen just recently, where they're like, okay, well, that's not really what we wanted, but they're going to have to do it this way.
Right.
So you might want to talk about that just a little bit, because that 5-year period is somewhat deceptive, I think.
Well, it's not if you understand it, but it's deceptive because of everybody's opinion of it.
Right, exactly. That's what I'm talking about.
Yeah.
There's a lot of misinformation about how that works.
That's right. Well, I mean, probably that's a pretty big topic, but
It is.
we'll hit the high points on it.
It is.
But I know what you're talking about. Talking about people gifting away their property during
Yes.
life
Yes.
to avoid it being an available asset,
Right.
available for their cost of care. And so the way that works is, now we're only talking about, when we talk about this 5-year rule, we're only talking about things that you give away.
Yes.
Okay. Now, if you hear people, it's called the 5-year rule or the 5-year look back rule.
Yes.
Right, is what you'll hear. And when you say that, I guess we can only determine two things. One, it's a rule, and two, it has a length of 5 years.
Yeah.
It's kind of silent on the beginning or the end.
Yeah.
But whatever the beginning and end are, we know there's 5 years in between the two, right?
Right,
Is
right.
about the best we can get. So let's talk about that. That is a future event for most people.
Yeah.
The 5 years. Like for you and me, 5 years hasn't started yet. Okay. The 5-year period doesn't begin until you are in a facility and you file a 10-care application seeking benefits. Okay. And if we filed a 10-care application right now to see how it would work out, it would be rejected because you have to be institutionalized to file a 10-care application.
Yes.
And so, you have to be in a facility to even
Yes.
file one. So we're not in one, so it's a future event. But let's fast forward 20, 30 years, and we're in the nursing home.
Yeah.
And we decide, I want to get 10-care to pay my bill. And so I fill out the 16-page 10-care application. I send it into them, right?
Yes.
And they get it. So one day they get it and they stamp it received, right? Or the fax stamp, right?
Mm-hmm.
That is day one of the 5-year period. Okay. Now that 5-year period is going to go backwards in time for 60 months. They call it 5 years, but technically it's 60 months.
Right.
And it's a jurisdictional time period, which means it's not 60 months in a day, it's 60 months. And what happens when you do that? When you file that application, you've given 10-care the right to look into your financial history for 5 or 60 months.
Backwards.
Backwards, right.
Yes.
So if you did it today, it's going back to, January the 2nd, 18, right?
Yeah.
Or 19. And so
Yeah.
You've given them the right to look in your financial records 60 months. Now, what are they looking for? Are they looking to see, what kind of drawers you bought at Walmart? Or are they looking to see, what did you spend, what kind of movies you go to? No, they're not. What they're looking to see, the sole thing they're looking for is whether you gave anything away in that 60 months for less than fair market value.
Yeah.
Now, this 5-year rule only, I say again, only applies to giving stuff away.
Yes.
I call it gifting away because when you say you give something away, it implies you don't get anything for it.
Yeah.
But it's more than just giving it away. You can undersell or overbuy.
Yeah.
So if you have if you give a house that's worth $200,000 to your child, like you referenced a minute ago,
Right.
you write out a deed and you pretty much say for $10 token consideration, I give this to my child.
Right.
That's a $200,000 gift because they didn't pay you $200,000 for it, right? If you gave that house to the fair market value, which is the tax appraised value on the tax card,
Yeah.
that's what 10-care calls fair market value.
Okay.
It's not what you can sell it for.
But that's what they're going to use.
That's the one they're going to use. Yeah.
Yeah.
And if you gave it to the child and the child gave you $100,000 for a $200,000 house, that's going to be considered a partial gift because you gave it away for $100,000 less. They're going to look at that like you gave $100,000 of that away.
Right.
And so now this 5-year look-back rule only applies to this giving stuff away. It's actually called a divestment. Divestment means it's leaving you ownership.
Right.
And so they're looking to see if you gave anything away for less than 5 years. And if you did, they're going to flag that and they're going to do something about it. Okay, they're going to impose a penalty period.
Yes.
And a penalty period is a period of ineligibility. So let's just say you gave away a $300,000 house. And then 3 years from now, like you said, people do that and then it blows up on them. So they give it away and the theory is we're going to stay out of the nursing home for 5 years. Because after that, At 5 years and 1 day, at 60 months and 1 day, they can't look back. They can't see that. I mean, they'll see it, but they can't do anything about it.
Right.
It's jurisdictional. It has to happen in that 60 months.
Right.
In the law, there's these time periods, and they're absolute. And so if it's 5.5 years ago you gave it, then there's a non-issue. It's a gift. It's given. There's no negative effect of that.
Right.
But if you, like you said, if it blows up on you and you give it away, and then 3 years later your health goes south and into the nursing home you go,
Right.
and you want TennCare to pay the bill because it's over $10,000 a month now, then you file the application. That's squarely within the 60 months, and they're going to see it. And you have to disclose the bank records. I mean,
Right.
if you don't, they'll just deny you for not giving them what they asked for. And so you have to give it to them, and they'll find it. And let's just say it's a $300,000 house, and that's the only one. Typically, they'll add them all up over 60 months if you've done more than one.
Yeah.
But let's just say that's the only one, and they'll take that, and now they will impose a penalty period, which is a period of ineligibility. And that period of ineligibility is based on the value of what you gave up.
Yes.
Has nothing to do with 5 years. Meaning, in other words, the 5 years is only how far back they can look.
Yeah.
A lot of people are under the impression if you give something away, then you got to automatically wait 5 years before you're eligible. It's not the case. The term of time you have to wait because of the penalty period is based on the value of what you gave away. And what they'll do is they'll take the value of what you gave away and they'll divide it by a special number, which just changed, and I don't have it committed to memory. It changes every January 1st, okay? But for the year of 2024, it was $8,220 dollars per month. So they'll divide that, and that's how many months they'll impose a penalty period for. And the logic is simple. It's like, okay, we're going to impose for a $300,000 house, it's like 36 some months, okay? They're going to say, we're going to impose a penalty period of ineligibility for 36 months. You're eligible, but we're not going to pay for 36 months because you gave away an asset that had you kept it, you could have used that to pay us for that 36 months.
Right, right.
The $8,220 a month is based on the average cost of care. It's actually lower, but it's better than it was. But So, it's not an automatic 5 years. Suppose you only gave away $8,220. You'd have a penalty period of 1 month.
Right.
So the 5 years is not automatic 5 years penalty. It's how long they can look back from your application to see if there was a qualifying event. If there was one, then they impose the penalty period based on the value of what you've done. And so, you said it blows up on people. Yeah, that's a problem.
It is a problem. It is a problem.
The penalty period is very harsh because let's take that $300,000 house and say there's a 36-month penalty period.
Yeah.
And what are your choices then? You either private pay, but it's like, I don't know if I can private pay. I kind of gave all my stuff away, right?
Yeah.
Or you don't get the care.
Yeah.
Which is pretty harsh. You know what I mean? So, but there's, I don't have time to get into it, but you can fix a penalty, you can cure it if you get the asset back, stuff like that. But, the concept of the 5 year rule, it's very, very misunderstood.
It is. And even if you've done it right, here's one, and this is kind of, I may be outside of where you want to go with this at all, but once, if you are the recipient of that gift, and let's say the 5 years passes and everything's ducky and all that kind of stuff, but you now have this asset.
Yes.
You now have the asset.
That's right.
And if you decide to sell that asset, there are tax consequences.
Well, and if you got it by somebody gifting it to you during life, the consequences are even greater.
That's what I'm saying.
Yep.
And I've run into that. They're like, holy cow.
Yeah.
Because they didn't realize there was a kind of a tax tag on that thing too.
And that's a capital gain.
That's called a capital gain.
Yeah.
So there's all these things that need to be considered when you do this.
Well, let's talk about that.
Okay.
As we're coming down the wire, because that's something you need to be aware of. You can. I mean, people say, "Can I give property away?" And certainly, you can give it away anytime you want. You just need to know the baggage that goes with that.
Right. Exactly.
You can give it away, and so people will give it away and hope they'll go into nursing home for 5 years. We call that divest and wait.
Yes.
Another thing to do is divest and insure if you can get long-term care insurance.
Right.
But if you divest and wait and you clear the 5 years, it's never an issue for you now. But of course, when you give a piece of property away, let's back up a little bit. If I have a piece of property, let's say it's worth $300,000.
Yes.
I have what is called a tax basis. My wife and I, we have a tax basis. And that tax basis is basically what we paid for it.
Yes.
So let's say 30 years ago we paid $100,000 for it. I'm just using round numbers, right?
Right.
And now it's worth $300,000. If you give it away to somebody and just deed it to them,
Yep.
there's no sale or bargain for exchange in which to calculate a new tax basis for the new owner. Therefore, the new owner gets your tax basis. So if I give a $300,000 house to my kid, I've just handed him a potential $200,000 capital gain problem
Yep.
because he gets my tax basis. So when he sells it, if he sells it right away, he's got capital gains on $200,000. Now, if he waits a while, it goes up, but it still starts from that low number.
Sure.
Now, if you give property after death, so if I have a trust and I say, leave this same house, I leave it to my son.
Yes.
When he inherited it at the second death, his tax basis is now the fair market value. Fair market value.
There you go.
Fair market value the day of death.
Yes.
So let's say it's worth $300,000 the day of my death.
Yeah.
My basis is $100,000. It's worth $300,000 at death. He inherits his basis is now $300,000. So if he would turn around and sell it the very next day, there's no capital gain.
Yeah.
But if he hung on to it for 20 years and it went to $500,000, he'd have his own $200,000 gain, but it would have started from this stepped up number.
Yes.
So that's a big advantage to your children to leave property after death.
And that's really good knowledge to have.
Yep. Now, I've seen this happen, and I've been able to cure it sometimes. Some people will gift very valuable property away, like the family farm.
Yeah.
What's that? A family farm is, I think it's sold. I mean, it was valued at $2.5 million.
Yeah.
And it was bought quite a while ago, like in the 20s or something.
Right.
For like $30,000.
Oh my goodness gracious.
And now they gifted it away, which is like a 20-some year penalty period.
Oh my gosh.
But what they did was the person they gifted away just kept it until death and then left it to their children. And that step up in basis now cured what happened with that generation.
That's true. That would cure it.
But I mean, capital gains taxes is a little out of my lane. I know how they work, but I'm not giving tax advice here. But you can get out from under $250,000 worth of capital gains tax if it's your primary residence that you're selling.
Yes.
And it could be $500 for a couple, $500,000.
Yeah.
But and that's an incentive for people that want to buy a home and sell a home and buy a nicer home.
Right.
And it's a disincentive to people that just like flip houses. They don't
true.
get out from under that if you buy it, fix it up, and turn a profit on it. You know what I mean?
Yes, I do exactly what you mean.
Get out from under the capital gains thing. That $250,000 forgiveness is for the primary residence.
Yep.
So knowing how capital gains works. Now sometimes that's all we can do is give it away. We may have to do that.
Yeah.
You're right. But when we give it away like that, we know the consequences of what we're dealing with.
Yeah.
So that's if you're going to gift property away, there's that goes with it as well as the 5-year rule you're talking about.
Sure. Interesting stuff and life-changing stuff. It could affect you and your family and your family's future to know these kind of things and be able to have a system or a plan set in place. And that's what estate planning is all about.
Yeah. I mean, and it's like, I talk about knowing the options. That's exactly what we just got done talking about, knowing the options. Probably not a good idea to go across the street and ask your buddy across the street, and he says, you need to give your deed away to your kid, before the nursing home comes and takes it.
Yeah.
And people sometimes act on that. I'm not sure why. Probably not the best idea to do that because, they get the facts somewhere and understand it.
That is true.
Now, we talk about that very thing that we just talked about, this 5-year rule, during the seminar.
Yes.
And I like to tell people, I said, when I'm done talking about this 5-year rule, you'll be 1 in 100, if not 1 in 1,000, that know and understand this 5-year rule, what it really means. You may not like it any better, but at least you understand what the heck it is.
Right. You know what's happening anyway.
And I know it's misunderstood because you'd be surprised how many people will call me and say, Stan, I want to sell my house, but I'm worried about that 5-year rule.
Yeah.
Now, what's wrong about that statement?
Well, they're selling the house.
That's exactly right. You're not giving it away. If you sell the house, if you have a $300,000 house, you have a $300,000 asset, do you not?
That's right.
Now, if you sell the house and you get a $300,000 check, you still have a $300,000 asset.
right.
Your position has not changed one iota. It's just the asset just changed posture from real estate to cash, right?
Right.
As far as TennCare is concerned, or any creditor for that matter, you still have a $300,000 asset.
Yeah.
So the 5-year rule doesn't apply to that.
Let's talk about that for just a second. Let's say this is just I'm just throwing this out for because it just hit me. Let's say that person did sell their house for $300,000 or whatever. So now they've got this cash, and they just say, "Well, I'm going to give that cash to my son." How does that throw a wrench in the fan rather than just giving him the asset, the house?
Actually, it doesn't change a thing.
Doesn't change
It's still a
anything.
$300,000 divestment, a gift.
Yes.
And that 5-year penalty is in full force and effect once you give it away.
Okay.
Now, there's no capital gain thing anymore because, that would have been paid by when you sold the house.
Yeah, I guess that's what I'm getting at. Is you could avoid that capital gain thing for the recipient of that $300,000.
The seller would have to pay the capital gains tax.
Right,
Yeah.
right.
Now, if they take the proceeds from that sale and give it to the child, that's still a gift.
Right.
But it's a gift of cash now. Mm-hmm. And again, it's you
And
gave
I
it
don't know
away.
what the tax consequences of that are.
There's no tax. It's a gift.
It's a
There's
gift.
I get that asked a lot because that's part of our asset protection trust is that you
Okay.
can distribute property out of it to certain people.
Okay.
When you do that, it's a gift. And the only person that ever pays taxes on a gift is the giver of the gift.
Okay.
And the only time the giver of the gift ever pays taxes on the gift is if the sum total of the lifetime gifts plus the estate at death exceed the federal exclusion amount, which right now is $13.6 million. That changed the first two. I haven't seen new numbers yet.
$13 million. Okay.
Per person, 13.6. Now I'm sure that changed too. It usually does every January. And I guess being the third, I had a very busy day yesterday, and I didn't download the new numbers, but that's something we'll do here real soon. So.
Well, it's a new year, and you're going to have new numbers, I guess.
And they don't always come out on the very first day either. So.
Yeah.
But yeah, I mean, giving stuff away is a concern. That's one of the two things we focus a lot of time and attention on is when you gift away property.
Which is basically what estate planning is all about. Your whatever your assets are, whatever your possessions are, when you leave this world, you're wanting to give those or see that they go to whoever you have decided they go to.
Exactly right.
And so whatever that is, I mean, you're gifting these things.
Now, along we're on that topic, the other question I get that concerns people or scares them sometimes when I talk about this during the seminar, because I said talk about this gifting away in the penalty period, inevitably there's somebody in the audience that has done that.
Yeah.
Okay, and
Yeah.
it's less than 5 years.
Yeah.
And they start to break out into a sweat. So let's imagine this. Let's say you say, "All right, son, here's my 150 acres. I'm giving it to you, $300,000." And it's 3 years ago.
Yeah.
Now I get sick and go into the nursing home. The question is, now in that 3 years, my son borrowed a couple $100,000 from the bank so he could build on that piece of property. Now he's built a house on it,
Right.
paying off the debt.
Right.
Can they come and take that property away from my son because I gave it away?
Yeah.
And of course you're shaking your head. So you're right. The answer is no. They cannot do that.
They cannot do that.
That's the whole idea of the penalty period. What they can do is punish you for giving it away.
Yes.
They can't do anything. When you deed it to the child, ownership is complete. It's a
Right.
complete transfer.
Right.
You've divested yourself of it. They can't go and take it from him and bring it back. But what they can do is penalize you for giving it away.
Yes.
And that's what the penalty period is all about.
That's what it.
And now when you do that, that's considered one of your lifetime gifts. And so they want to keep up with your lifetime gifts. So when you give property away, you may have to file a gift tax return and again, you never pay a tax, but you may have to file the gift tax return. And the reason you want to file the gift tax return is they want to keep up with the sum total of your lifetime gifts. And if that plus your estate at life exceeds the 13.6, it's still not a gift tax, but it could be an estate tax.
Yes.
And so.
But it has to exceed that 13 plus.
That's right.
million.
And that was supposed to come down with the sundowning of those laws, but now because of the election, they're probably going to stay up there pretty high. It's too early to tell where they're going to stay, but they're not coming down much if they come down. So
Right.
So people that get concerned say, "Oh my gosh, I gave a kid to my daughter, and she borrowed money and built a house, and now they're going to come and take it from her." The answer is no. Don't worry about it. Stop sweating. It's okay.
Yeah.
What they're going to do is hammer you for giving it away.
Well, we've got about 4 or 5 minutes left, and I want to remind everybody of your seminar coming up.
Yeah.
And you say there's already beginning people are registering for it. And she did ask about, if she signed up and couldn't come. Why don't you address that?
I think she said, is it better to come?
Is it better to sign up
and not show?
Sign up and not show, or
show up and not sign up?
She made up, but I think you'd rather have people sign up and hopefully get there.
It happens both ways every time.
Yeah.
We have people that sign up and at the last minute can't make it.
Yeah.
And that's okay. And it's okay even if you just don't show. I mean, you don't have to call and tell me. But,
Yeah.
And it's okay if you can't commit to it, or in the morning of, you think, you know what, let's go to that.
Yeah.
We have people just walk in all the time. It's
Right.
no big deal. The only reason we like to get sign-ups and RSVPs is so we set up enough tables and chairs. We have light refreshments. We want to make sure everybody's enough for people to
Right.
have some muffins and whatever the girls make for them. So,
Yeah.
but you can sign up now. Usually when I announce a seminar, we get sign-ups from the very first day that I announce it. And then now we do them a little farther apart now, so I'm announcing them for a longer period of time. But it's not too early. We have quite a few sign-ups so far. I have to check and see. Ms. Courtney keeps track of those things, and she reports to me every now and then about what it is. So as we get closer to it, she'll, and as we get closer to it, we'll get more sign-ups, as it becomes more and more.
And this one is scheduled for
The 25th.
25th.
Now, that's a Saturday. We're doing more and more on Saturdays, and that's by popular demand, really. And so it's on Saturday, and we do Saturday seminars at 10 a.m. And it's going to be right here at the WLX radio station.
Yep,
back
right
in the
behind
building.
us, right
Yeah.
behind here.
Same building, just in back.
That's right.
And there's a set of double doors back there. I like to tell people, you got this 350-foot tower. It's the tallest thing in Orange County, I think. And it's like if you follow that tower to where it touches the ground,
Yes.
there's a double door right there.
That's right.
Come on in. You found the place, right?
That's right. You found it.
Yeah, don't walk in the front door of the WLX radio station. That has happened, and whoever's here on Saturday ushers them to the back.
Yeah.
But it's called Will's Trust in the Nursing Home, 10 o'clock on Saturday the 25th. And that's what we're going to talk about. We'll talk about will versus trust. We'll talk about trust a little bit. We'll talk about this TennCare planning, this asset protection, or how not to go broke in the nursing home if something happens to you. That's exactly what we talk about. We discuss a lot of options. Be prepared to hear things you may not have ever heard before.
Yeah.
That's okay. Just because you haven't heard it doesn't mean it's not out there.
That's right.
It just means you haven't heard it.
That's
so
right.
come with an open mind. There's a lot of things I know. You've even experienced some of those things that didn't know existed and can make work for people.
That's exactly right.
So, sign up for it. Call my office at Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222. Or you can go to my website, which is estateplanstand.com, and you can ask a question that way, or you can sign up for the seminar that way too.
Very good. Stan Pierchoski Estate Law, located on the Square in Pulaski, Tennessee. I was going to ask you about the Star Theater right quick.
Yeah.
What's coming up on that?
Something in the very early works. They did auditions for Finding Nemo Kids.
Oh, yeah.
And
yeah.
What's going on? We affiliated with an outfit up in Nashville. It's putting a play on up there off of the Broadway Street.
Yeah.
And it's called Philopathy, and it's the musical. It's about a miracle healing.
Oh, really?
And two of our star actors are in that. We're casted in it. One is my wife, Miss Tammy, and another is Miss Paige Barnes, who played Betty Rizzo. They're in that. And it's one show Tuesday coming up.
This coming Tuesday?
That's right. And Star has provided a lot of the props and a lot of the stage stuff, and also a lot of the wardrobe. And so we're working with them on
Will
that.
this be at the Star Theater?
No, it's up in it's off Broadway.
Off Broadway in Nashville.
Yeah, I forget the name of the place, but
Oh, how about that?
give us a call and we'll tell you where it is. But
How cool is that?
why it's just one show, I don't know, but that's
Yeah.
We're just working with them on the props and sets and our pool of talent.
Okay. Very, very good. Very good. Always fun to do those. And I know you've been involved, you and your wife, a lot. All right. Well, it's been an enjoyable discussion this morning.
Yeah, we are right on
we've
time.
Kicked off the year just right.
Yep.
Remember, estateplanstand.com. Estateplanstand.com. That office number, 931-363-7222. Good to see you, my brother.
And we're here every Friday from 8 to 9.
That's right. See you next time.
See you next time.
Prospect Communications.
Presidential meddling. I'm Dave Anthony, Fox News. A Japanese company's attempt to buy American blocked at the White House, where Fox's Jared Halpern reports.
Making good on a promise last year to prevent Japan's Nippon Steel from taking over U.S. Steel, President Biden officially blocked the deal, writing in a statement the proposed sale